Members of Convocation, we've now received the oral submissions of Trinity Western University, and we are now entering into our deliberations phase. I already have a fairly lengthy speakers list, but I'm going to go to the phone first and just take
the conference is no longer in lecture mode.
So I have. Mr. Bannock? Mr. Bannock? Mr. Furlong? Mr. Furlong, you're there? Okay, thank you. Mr. Lerner?
Present.
Ms. Richardson?
Present.
Mr. Strasberg?
Yes, I want to speak, please.
Yeah, okay, you're noted. We'll put you on the list. Mr. Armstrong? Mr. Armstrong? Mr. Yacchetti?
Yes, sir, President.
Thank you. Ms. Potter? Ms. Potter? Mr. Wright?
I'm present, and please add me to the speakers list, depending on what's said between now and then.
Do you want to be added to the list or not? Yes?
I do, but if my points are made, then I'll prepare at that time.
All right, thank you, Mr. Wright. Mr. Hunter?
Present.
Mr. Maines?
Present.
Anyone on the phone whose name I have not called?
Yeah, it's Jacqueline Horvath. I'm on the phone now.
Ms. Horvath, okay, thank you. Anyone on the phone that wants, at this point, to be added to the speakers list? I've noted that Mr. Strasberg and Mr. Wright are going on the speakers list. Is there anyone else on the phone that wants to be added onto the list at this point?
Please add me, Mr. Lerner.
Okay, thank you, Mr. Lerner. The first I have on my list is
The conference
Constance
is in lecture
Backhouse.
mode.
Thank you, Treasurer. And on behalf of myself and the rest of the benches and the Treasurer, I want to thank the President of Trinity Western for his written reply brief and his oral submission today, to which we have all listened. I wish to speak to a very small matter that has been raised in the previous convocation by Janet Miner and is raised in some of the submissions. It has not, I don't think, been addressed fully yet. So I will keep my remarks brief and address a piece of the discussion that I think has been lacking. Some of our debate has hinged on the characterization of Trinity Western University as a private university, an institution that is funded without public resources. With the greatest of respect, I wish to take issue with this and to make a few comments about why Trinity Western Law School would be a public institution. First of all, law school positions are public in nature. Access to legal expertise is deeply beneficial to those who wish to understand and influence legislation, regulation, all aspects of justice. Not only does going to law school give people access to that expertise, but it positions law graduates in places of economic privilege and social stature. Without a law degree, one cannot be a lawyer. One cannot be appointed a judge, the latter being a position of enormous power and influence. The consequence? Students who receive acceptance to a law school obtain a public good. Trinity Western defines itself as private, but all law school positions cross over into the public domain. As a result, when we approve a law school for admission to our bar, we must ensure that we keep access to those important law student positions open to the full diversity of our population. No group should be prevented or discouraged from attending because of same-sex affiliation, because of gender, race, or religion. Secondly, this public good is in short supply. At the University of Ottawa, for example, for every law student we admit, there are approximately 10 qualified applicants who do not obtain a spot. Over the past 30 years, no new law schools were established between 1980 and 2010. That's a 30-year period where there were no new law schools. And indeed, Canada remains the country with the lowest number of law schools per capita of any Commonwealth country. And as we know, offshore law schools have ramped up to service the wealthy members of the overflow at tuition rates that are substantially higher than most Canadian rates. Provincial governments have slowly begun to set up new law schools, but these are by no means equipped to capture the full demand. And once a new law school is established, governments will be disinclined to approve others in the same geographic area. Approval of Trinity Western will shut down applications and approvals for other law schools in its wake, and its existence will reduce open access to prize positions. Thirdly, and here I am drawing most of my material from the submission that is in our board books from a tax expert, Professor Kathleen Leahy at Queen's University. My third point, Trinity Western does not operate free of public funding. Trinity Western students are eligible for post-secondary governmental funding. This includes student grants, interest-free student loans, and numerous tax exemptions for tuition, educational living expenses, books, research grants, and scholarship funds. In 2013, Trinity Western reported $21 million in student financial support. As a university, Trinity Western operates without having to pay governmental income tax. It obtains rebates on GST and sales tax. It qualifies for property tax exemption. And because Trinity Western is a registered charitable organization, its private donors receive income tax credits for charitable donations. In 2013, private donors gave Trinity Western $5.5 million, which would have triggered deductions, non-refundable tax credits, and partial or full exemption from capital gains liability. In addition, since 2009, Trinity Western has reported receiving direct cash grants from all three levels of government that over 5 years came to a total of $7.3 million. Now, Trinity Western claims to be a private university, and this is the first time that the Law Society of Upper Canada has had to consider an application by an institution claiming to be private. We should be under no illusions here. To the extent that the designation as a private university will be used by some members of the Law Society to sit on its hands in the face of discriminatory restrictions in access, it is a misnomer at best and a deceptive argument on the whole. Thank you.
Mr. Campion?
Thank you, Treasurer, and welcome to my friends from Trinity Western. I start off where I started off the last time, and that is you are among friends and you are among defenders. In my respectful view, all of us will defend your right to hold your beliefs. And I hold many of the beliefs that you hold, but some of them I don't. In my respectful view, Treasurer and benchers, this is best analyzed in one single moment, when a student is asked and required to sign the covenant. It's not about the nature of the graduates. It's not about whether they're qualified or not. As some of you know, I was the president of the Federation of Law Societies. I was on the Federation of Law Societies for 5 or 6 years on its executive. I set up the committee that our treasurer chaired, dealing with the accreditation of law schools. I have been involved in this debate intimately for a very long time. The proudest thing that we have done, in my view, in my time, is to have made the Federation come to life. We have done it by uniform standards, and one of those issues was giving the job of the Federation to accredit law schools, looking at what are the requirements of a law school. But the Federation did not, and has not considered the issue, in my respectful view, of the public interest of Ontario in accrediting a law school if there is a discriminatory part. It is my personal view that the covenant has nothing or little to do with religious freedom. The covenant has to do with sexuality, sexual practices. Some may say that is a religious matter. I don't think it is, but that's my view. And we're not here to discuss my view. But with that view, I say this: I don't think that the rejection of, or not accrediting today, is an attack on the Trinity Western religious freedom. I support the religious freedom. I'll defend it. I'll defend it if asked. But it doesn't mean that when I come to analyze at the point of signing what the implications are for the person who has to sign it. And if it's discriminatory in a way that's contrary to the public policy of Ontario, we are obliged to reject the accreditation. The Federation then is put into a quandary. My friends have dealt with it. The Federation is one robust organization. It will survive a difference of views between Ontario and British Columbia, Alberta, PEI, and all the rest. It will survive it. It will find a way through it. It is complicated, but we only have one issue today. What's the public policy of Ontario? We're obliged to deal with it. We have a statute that is nothing more than saying we are exercising the authority that the legislature would exercise, and they've given it to us. And would the legislature of Ontario credit and allow a policy which is discriminatory in the field in which we are now dealing with? In my view, and I'll come to it in a moment, I think the answer is no. My second point is that besides the issue of sex and sexuality and sexual diversity not being a purely religious point from my perspective, and I recognize my friends have a different view, possibly, the freedom of religion is not engaged for a second point. We aren't attacking the freedom of religion. People can go to the school, sign whatever covenant they want, and some of us may even support some of many parts of the covenant. But the question is the point of signing. Does that lead to, and this is my third point, a position where the person who has to sign, and I'm assuming they're signing with all solemnity, do they feel a sense of guilt, humiliation, restriction, feelings of inferiority when they have to sign it if they happen to be of a particular community or sexual persuasion or sexual activity? What if there's common law marriage or live in common law? Do they have to not tell the truth and go to the university anyway because they're so desperate to do it? But it's the feelings of inferiority at the point of signing is the only time I'm concerned about. I'm not concerned about the graduates. I'm not concerned about what they teach them. I know they're going to have a brilliant law school. The Federation's told us so. That's not our problem. Our problem today is one thing and one thing only. If it's discriminatory and contrary to the public policy of Ontario, we cannot approve it. We, as you have heard me say, and this is my fourth point, are exercising the Law Society's public Ontario discretion. Federation couldn't do it, can't do it, doesn't know it, wasn't obliged to do it, shouldn't have done it. The central interest is, in this, in my respectful submission, is identifying what that public interest is. It's plain that it's overwhelmingly in favor of diversity, of sexual orientation, and sexual relations outside of marriage. Gay marriage is embraced in this province. Common law relationships are recognized in this province. Sex and sexuality are left to the private bedrooms of the province. This covenant would necessarily, in my respectful submission, restrict sexual preference, orientation, and activity between consenting adults, which is either no concern of the province in terms of the private sexual activity or supported by the province in terms of diversity. So what's the public interest in Ontario? In my respectful submission, it is the kind of diversity that would say we cannot allow this covenant to be part of us accrediting a law school because it's one step backwards. And what about all the men and women who, some of whom are living and some of whom are dead, who were in my world? Lawyers, prominent lawyers, superb lawyers, I won't name them, but they lived in great pain because they were gay. And I was junior to them, I was colleagues with them, still am, whether they men, women, transgender, whatever they are in terms of their sexual orientation, they lived under humiliation. And I saw it happen in the profession. I knew what it was to be an outsider through the eyes of these people in the Ontario in which I grew up. It was a less tolerant place. And the proudest thing that I have been part of is to watch, and usually through the efforts of others, but I've sort of helped it along as best I could, is to watch how this province has become a diverse place. It is astonishing to see, when I think of where I was when I went downtown with my father in 1950, compared to today. There is no comparison in terms of the issues of tolerance and diversity. And I don't think we should take even a millimeter of step backwards. We can't do it. All that work and all that trouble and all that pain, and we're going to take one little step backwards? I say no. It has got nothing to do with the freedom of religion of TWU. I support them. I'll defend them. The allegations of placing them in the same categories as some of my colleagues have placed them, I reject. I heard Mr. Kuhn speak. It was obviously very painful, but that's not where the issue lay, in my respectful view. My respectful view, it lies in one point. It's a point of signing. And is that point of signing discriminatory of the person who does live in a common law relationship, who is sexually active and homosexual, or gay, or transgender, or whatever? And in my respectful submission, much to my great sadness, the President of the Federation, a prior one, we will survive whatever this difference is. But I believe we are obliged to apply the public policy of Ontario, and we ought not to credit it. I'm much obliged.
Ms. Leeper?
Thank you, Mr. Treasurer. Treasurer, members of Convocation, representatives of TWU. I wish to first acknowledge the rich legal and policy opinions and the submissions that we've received to assist us with this question. I thank TWU for its reply submissions and presentation this morning. We heard from you, President Kuhn, about hurtful public remarks today, so I need to begin by acknowledging our shared humanity and a desire that our deliberations and decision today will be made and received respectfully. So, we meet here at an intersection between public policy and privately held belief, and the tension has been described by many about competing rights. Right to freedom from discrimination on religious grounds versus right to freedom from discrimination on grounds of sexual orientation and marital status. This approach to balancing these two sets of rights was followed in TWU and BCCT. And TWU submits to us that BCCT and TWU has virtually decided the question, that we are bound to follow the reasoning from the Supreme Court of Canada in 2001. Significant portions of our materials focus on the application of that case here today. I have 3 points to make. The first is my reason for why I've concluded that TWU and BCCT does not bind us. The second point is why this case is helpful to our decision, and the third is my reason for the decision. First point, we are not mandated to follow BCCT because of the development of the law around when freedom of religion is engaged since that decision took place. And this relates to my question from last day. I asked about the relationship between freedom of religion and accreditation of a law school. And I wanted to understand how our decision for or against engages freedom of religion. And I did find help in the TWU submission, paragraph 94, page 3046 of board books, citing a portion of a case called Syndicate North Crest in Anselm, a 2004 decision of the Supreme Court of Canada. TWU cites Syndicate North Crest to support its position that the right to establish and maintain a law school within a Christian university need not be required or mandated by religious belief to be protected. I thought at first maybe this was a case involving a law school. I was hopeful, but it wasn't. In Syndicate North Crest, the Supreme Court of Canada carefully considered when and how a given set of facts gives rise to a claim of freedom of religion. There is no need to prove that a particular practice is an established practice, a part of dogma, or is even condoned by a majority of religious officials. And to question adherence closely would be objectionable, because the state would be intruding into the religious affairs of synagogues, churches, mosques, temples, and religious facilities. But nevertheless, there is a test, articulated at paragraph 56 of Syndicate North Crest. 2 parts. There are practice or belief having a nexus with religion which calls for a particular line of conduct, either by being objectively or subjectively obligatory or customary, or by, in general, subjectively engendering a personal connection with the divine or with the subject or object of an individual's spiritual faith, irrespective of whether a particular practice or belief is required by official dogma or is in conformity with the position of religious officials, and is the individual sincere in their belief. And here in this case, the TWU-BCCT case is mentioned twice, once by the majority and once in dissent by Justice Binney. The majority cites BCCT for the proposition that not every action will be summarily unassailable. Justice Binney notes that freedom to act is narrower than belief. TWU, again, was very helpful. They described the importance of its community covenant to its evangelical beliefs in the metaphor of Christ and the church. Marriage is defined as part of this practice as having this special, particular meaning, and this is the aspect of conduct that is a manifestation of religious belief. TWU says to us, the covenant and its values are not our business here, not the business of the Law Society. The covenant is protected. It has a nexus with religion. And TWU says it's not our job to regulate the covenant. I agree with that. However, our duty lands on the examination of the nature of a proposed law school, which degree we are asked to accredit. This must include policies that could engage broader public interest concerns, including whether there is a discriminatory impact on members of the proposed law school. At this stage, for these purposes, it is not material whether the beliefs stem from a religious or other worldview. It is what the policy does in relation to members of the law school that is our concern. It is not yet about balancing rights at that point, because you only get there when the conduct being affected and accreditation of a law school is itself part of the religious practice. As Laforet noted in the Ross decision, also referred to in the materials, you need to place conflicting values, allegedly conflicting values, in factual and social context. So coming back to my question, does the operation of an accredited law school, is it a vehicle through which students and faculty exercise freedom of religion? Is its primary purpose the dissemination or teaching of religious beliefs? These are some of the contextual questions that assist us with understanding the role of 2A of the Charter. In my view, respectfully, the accreditation of TWU's law school does not have a nexus with religion. Instead, it is coincidental with a code of conduct for students that is grounded in religious belief, but is not itself a religious practice, or a manifestation of that belief. And it's tempting, and many have done it, to intertwine the teaching of law with freedom of religion, but ultimately it is not logically connected. As far as the institution of accredited law school is concerned, it has departed from the private domain. It has now crossed over into the public domain, the pathway to licensing. The factual context has shifted. TWU and BCCT did not apply the Syndicate Northcrest test. It didn't exist yet. It assumed the engagement of freedom of religion. Intervening jurisprudence has assisted us in similar questions by defining more carefully when freedom of religion is engaged by a given factual situation. So when I apply that test, I arrive at a different answer on the critical threshold question. My second point. BCCT and TWU continue to be applicable on the propriety of an accrediting institution considering equality concerns in the public interest, where the public interest is part of their statutory framework. In fact, our statutory duties are arguably broader than those of BCCT. But either way, equality concerns are important and deserve consideration following that decision. And my final point, my reasoning for voting not to accredit. Our power to accredit law school degrees amounts to a statutory power decision. Our duties and authority under statute is to advance the cause of justice and the rule of law, and we have a positive duty to protect the public interest. Our regulatory framework engages principles of equality that are protected by the Charter of Rights, protections from discrimination by the Ontario Human Rights Code. Our rules of professional conduct make it professional misconduct on the part of our licensees to discriminate. This is our framework. These are our values. And they apply to the regulation of the practice of law. We teach them, we model them, and we enforce them. And it is appropriate that we expect law schools seeking accreditation to respect them and ensure their programs of teaching law conform to these principles. It has been argued that if we do not accredit, we ourselves will be open to a claim of religious discrimination against graduates of TWU's law school. Respectfully, I disagree. The law school proposed is the source of the discrimination, and that institution would be responsible to its students for the impact of its own policy. Because the TWU covenant does not relate to the teaching and practice of law. It is part of a broader religious community within which it is proposed to create a law school, but its existence is not a conditioned precedent to the teaching of law, and in that sense it is arbitrary. TWU has committed to teaching human rights law, the Charter of Rights, public law, and ethics in conformity with an established law school curriculum. TWU does not object to teaching the Constitution or human rights laws. At this intersection between the values underlying the community covenant and the teaching of public laws and values, TWU has recognized and understood it must give way. It does not object on religious grounds to these aspects of the curriculum, and it recognizes without articulating it that law school teaching is not per se a religious practice. So, I conclude that the public accreditation of the TWU Law School is but a larger example of where and why it is appropriate to give way. I hope that TWU will consider that from an analogous perspective. The learning environment described by President Kuhn deserves such careful consideration by TWU. Accordingly, as a matter of public interest and public policy, I must respectfully decline to vote to accredit a program for entry to licensing when students attending and faculty employed at such a law faculty are required to conform to a code of conduct which is discriminatory and arbitrary to the study of law. This is analogous to authorizing another institution to do what this institution could not do, and what this institution insists its licensees must not do. Thank you, Treasurer.
Mr. Mercer.
The issue before Convocation today raises fundamental principles: freedom of religion, freedom of association, equality rights, and the rule of law. The rule of law plays central in this discussion, and I propose to start with a brief discussion of that. And I focus in that context on two cases from the Supreme Court of Canada that you'll all know and I don't really need to tell you about, but suffer me anyway. The first is Dunsmuir. Why is Dunsmuir important? Because Dunsmuir says that authorities such as Convocation, such as the Law Society, who are given authority by society, are responsible to exercise that authority within the limits of law. The fundamental importance of Dunsmuir, in my understanding of it, to the rule of law was that the courts acknowledged that they should not take on authority that was given to other decision makers, but rather they should ensure that those decision makers made their decisions within the limits of law. The rule of law principle requires that the appropriate authorized decision maker make decisions. The second case is Doré, and Justice Abella for the court in Doré asked the question, how then does an administrative decision maker, which we are, apply charter values in the exercise of statutory discretion? And to be clear, we're exercising a statutory discretion. Justice Abella said the decision maker should first consider the statutory objectives. And I think that is fundamental to the exercise before us. And I think we have to think long and hard about the statutory objectives pursuant to which we must decide. Justice Abella then went on to say, then the decision maker should ask how the charter values at issue will be best protected in view of the statutory objectives. This requires the decision maker to balance the severity of the interference with charter protection with the statutory objectives. As I said, we are called on today to exercise discretion. We must do so within legal limits. The wisdom of the rule of law principle is that we must be modest and only exercise the decision-making power that is assigned to us. We must do so as benchers, not as individuals merely making and expressing personal views and decisions. The written reply submissions of TWU rightly caution us to take care not to pretend to authority that we do not have. TWU also relies strongly, as a matter of the rule of law, on the decision of the Supreme Court of Canada in TWU versus BC College of Teachers, and I'll call it College of Teachers just to make it easy for me. On the other hand, the rule of law requires that we make the decisions that are our responsibility. We cannot and should not evade that responsibility. We must do our job. And I commend to you the advice from Fred Christensen setting out what are well known to us. We must exercise our discretionary powers in good faith and for a proper purpose. We must consider only that which is relevant, and we must consider what is relevant. We must exercise our discretion independently and not act under the dictation or at behest of any third party or body. We must give proper, genuine, and realistic considerations to the merits of the issue before us. So what does that mean in practical terms? We all know that that's our job as administrative decision makers. Where we have to start is interpreting the Law Society Act, because that's where we learn what our statutory objectives are. We have to come to grips as a matter of law with what is relevant. We cannot delegate this to the Federation. We cannot delegate this to the BC Law Society, the Alberta Law Society, or anyone else. And to state the obvious, the Supreme Court of Canada, dealing with the decision of the College of Teachers in British Columbia, did not decide or interpret the Law Society Act in Ontario. They couldn't do it. It would be silly for us to think they did. In my comments last convocation, I expressed the tentative view that our jurisdiction was not merely to consider the quality of TWU Law School graduates. I expressed the view that the faith of members of our diverse society and our democratic institutions depends on the rule of law, and equal access, that requires no limitations to entry to the practice of law other than learning, training, and character, and that a diverse profession and equal access to the profession is important to the rule of law and the cause of justice. I referred to section 4.2, which has also been referred to, and I won't say it again. I expressed my tentative views last day, expressly hoping that the subsequent submission by TWU would clarify and challenge my current thinking. I therefore read TWU's written reply submissions, and listened to President Kuhn's submissions today with great interest. I noted particularly the 3 paragraphs in the written submissions that address our statutory mandate. I won't read all 3 paragraphs, they're 57 through 59. What was said about our mandate in 58, similarly the Law Society Act mandates the Law Society to ensure that all persons who practice law in Ontario meet standards of learning, professional competence, and professional conduct that are appropriate for the legal services they provide. And then TWU says, it is in this regard that the Law Society of Upper Canada considers the public interest. The point which is made in this paragraph is essentially that all we are entitled to consider, the only public interest that is engaged, is with respect to the standards of learning, the qualifications of the individuals who graduate. And then the reasoning, having referred first to the teachers' mandate in BC, these mandates are very similar. There is not a legitimate or reasonable basis upon which to distinguish the College of Teachers case. That is the extent of the response to the tentative view that I put in the last convocation. I also noted 2 other paragraphs, 99 and 180, which state in part, the community covenant is relevant only if there is an impact on the qualification of future TWU graduates. And then in 180, TWU graduates should only be rejected if, on a proper evidentiary foundation, Convocation concludes that the education provided by TWU will be insufficient to prepare graduates for the practice of law. I was disappointed that the reply submissions failed entirely to address the proposition that the Law Society should not accredit law schools that effectively limit or impair admission on the basis of race, creed, religious belief, gender, sexual orientation, and the like, because of the importance of a diverse profession and equal access to the rule of law and the cause of justice. I initially thought TWU may have not seen this proposition as an issue. When I looked to their other non-issues in Schedule 2, I did not find this amongst them. It was curious to me that TWU would merely assert in a conclusory manner that the only relevant factor to consider is the qualification of its graduates. It may be that they think this is plain and obvious and needs no debate. It may be the failure to address the point is tacit admission that it's an argument that can't be met. I don't know what the answer is. Convocation shouldn't underestimate the importance, the pivotal importance of TWU's position that there is but only one relevant factor to consider, namely the qualification of the graduates. That's why they argue that the College of Teachers case binds us as a matter of law, because if the quality of the graduates is the only issue, then the Supreme Court of Canada has sensibly said, wait until they misconduct themselves, don't decide it now. And if TWU is right, that's the only thing we can think about properly, then I understand almost everything else that they say. But the College of Teachers case does not tell us anything about the rule of law, the pursuit of justice, the importance of a diverse legal profession, or equal access to the legal profession. On these issues, our failure to consider whether these are relevant considerations would be a failure of our responsibility to honor the rule of law, because the rule of law commands us to decide when it's our job to decide. I understand that people may take a different view than I do. My view is that we have long understood that confidence in the legal profession is fundamental to the rule of law, administration of justice, and the pursuit of justice. We've done that, as Ms. Christensen described in our role statement, which expressly says just that. We've done it in discipline cases. We've done it in looking at character assessment for licensing. We've done it in the context of defining what is professional misconduct in the rules of professional conduct. We know that making the public confident in the profession is fundamental. And I say and submit to you in these deliberations that a diverse profession with equal access to that diverse profession is part of that underpinning. Seems to me that ensuring a diverse legal profession and equal access to that profession is a proper statutory objective under our Act. Said simply, I do not accept this is just about the quality of TWU grads. And to be clear, the interpretation that I place is not focused on the proposition that some applicants may have their rights impaired. My approach is to look at the outcome for the administration of justice and the rule of law more generally. So I want to turn very briefly to Dore, because we're commanded to look at charter values in the context of our statutory objectives. It is possible to look this at a micro level and think through what I described last day as the Hobson's choice. Ms. Leeper put it nicely, it's not one we make, it's one which is put to us and put to the students. But I think stepping back, I see no inconsistency, I see nothing to balance, because it seems to me that charter values are entirely consistent with the statutory objective of equal access to the profession and diversity in the profession. I don't see an inconsistency. I think there is an alignment and no need to make them work together. A couple of final thoughts. First, a reflection on religious freedoms. It seems to me there's a spectrum here. Belief and expression must be amongst the most protected. Association, freedom of religious association must be important. We know that conduct is less important. The College of Teachers case tells us that. It seems to me to follow that freedom to control the conduct of others, including the sexual conduct of others, would be worthy of even lesser protection. I think this might properly be part of the Dore analysis if we have to get there. I also think that reflecting on President Kuhn's statement, submissions that underneath the strong opinions expressed by many is an underlying debate that's going on in our society. I think we are working through, in a really important way, whether freedom of religion, freedom of association includes the ability to restrict or exclude people because of who they are, as opposed to what they think or what they believe. And that's why I think the analogies of apartheid, the analogy of Arizona pizzerias, other analogies which were said to be irrelevant, some offensive, actually are relevant. Because I think that we're coming to the conclusion as a democratic society that a religion that excluded blacks, a religion that excluded women, a religion that excluded people because of sexual orientation would be exercising a freedom that we would choose not to consider a protected freedom. If we're not there now, I think we almost are. So let me conclude by making one final observation. Some here, and I listened to the benchers' debate in British Columbia very carefully, have expressed the view that they feel compelled to accredit TWU as a matter of law, but with unease and with concern. I come to the opposite conclusion after anxious, long reflection, during which I've held exactly the opposite view to which I express now. I freely admit that it was a difficult choice. But today I'm utterly at ease. I'm entirely comfortable with the legal reasoning and with the statutory interpretation of my view. What I don't accept is that in coming to it, I am condoning religious bigotry or that I'm doing anything other than my job. And if there was any suggestion that those of us in the room who may choose not to vote in favor of accreditation are expressing or condoning religious bigotry, I wish not to associate myself with that thought.
Mr. Faulkner?
Mr. Treasurer, colleagues, members of the TWU community who attended today, I want to say first of all that there are a few moments in our careers where we can comfortably say without overstatement that history may well judge how we do business and ultimately the conclusions we arrive at. This is one of those days. I remember using words like this before the Senate following the 9/11 tragedies and the extraordinary legislative overreaction of government. I remember saying to the Senate that one day my son or sons will be old enough to read these transcripts, and I want to be confident that when my sons read these transcripts, they believed in their father and they supported him and are confident he did the right thing. To my 13-year-old who will not read this transcript today, but when he does 5 or 10 years from now, I say to him, I will do the right thing. I will vote against accrediting TWU. I heard President Kuhn's heartfelt remarks, and I say they're heartfelt for a number of reasons. One can't but help sympathize for one who issues a plea to be protected against hatred. I do not support the kinds of commentary that President Kuhn and TWU has been subjected to. It's wrong. It's wrong no matter what interest you purport to protect. It's wrong to promote hatred. On the last occasion, April 10th, I raised a number of questions because I needed answers to those questions, and I looked to the materials and I listened carefully to President Kuhn today. The first question that I raised was, play this out in real time for me. A student finds themselves during their attendance at law school. What of their future at your law school? The student discovers their identity, determines that they're not exactly like the other students at TWU, and indeed may well be a member of the lesbian, gay, bisexual, transvestite, transsexual, intersex, two-spirited, or queer communities. Or simply they may wish to live common law with someone whom they love or don't love. I listened carefully for an answer, and with all due respect, President Kuhn, you did not give me an answer. I looked at the materials to search out the answer. And I refer my colleagues and those listening to the Community Covenant because the answer is right there. Page 2094 of Board Book. This is all about this covenant, and I don't think we put enough time into it. I leave it to my colleagues who do much better than I at citing Supreme Court of Canada prose. My steamroller legal analysis did not impress my colleague Venture Wardle, but I insist that the steamroller I worried about last day is actually here in this covenant. If you look at page 2094 of Board Books, 2094, under TWU Community Covenant, you will see that this covenant is held out as follows. I'm reading from the 4th paragraph. The covenant is a solemn pledge in which members place themselves under obligations on the part of the institutions to its members, to the members to the institution, and the members to one another. In making this pledge, members enter into a contractual agreement and a relational bond. It is an agreement, it is a bond, it is a pledge. Any doubt about the sincerity and the expectation of enforcement of that pledge is clarified at page 5, page 2098 board books of this covenant. This covenant applies to all members of the TWU community, that is, administrators, faculty, and staff employed by TWU and its affiliates and students enrolled at TWU. Expectations of this covenant apply to both on and off TWU's campus and extension sites. Sincerely embracing every part of this covenant is a requirement for employment. And this is the part that I was particularly found helpful to answer my question about that student who discovers themselves. Quote, ensuring that the integrity of the TWU community is upheld may at times involve taking steps to hold one another accountable to the mutual commitments outlined in this covenant. As a covenant community, all members share this responsibility. The university also provides formal accountability procedures to address actions by community members that represent a disregard for this covenant. That student, and make no mistake about it, that student who comes back after the summer becomes a target. They have to be, by the rules of TWU. I say with respect, then it becomes important to determine what are these rules. So we go to the covenant very quickly. Page 2095 board books. In keeping with biblical and TWU ideals, community members voluntarily abstain from the following actions. Quote, sexual intimacy that violates the sacredness of marriage between a man and a woman. Top of page 2096. And then further, 2097. Further, according to the Bible, sexual intimacy is reserved for marriage between one man and one woman. Honoring and upholding these principles, members of the TWU community strive for purity of thought and relationship. So we know, one, the methods of enforcement, and two, what the rules are. This is not, in my view, a healthy environment in the public interest. Why? Because I can't help but envisage the obligation a fellow student, a teacher, an employee would feel to, in essence, report someone's sexuality to the dean. Imagine a world in which your very movements are furtive for fear of being thrown out of law school. How can this be in the public interest? I said before, and I'll say it again, I have little doubt that the graduates of TWU have no greater chance of being biased and no less chance of being biased than many other judges and lawyers I've met in my life. I believe that the school no doubt passes the adequacy standards the Federation looked at. That's not the issue. It's whether the environment being created is in the public interest. Not every lawyer does, but I find most do, certainly all of them in this room, see the practice of law as a calling. It is our profession, it is a calling. Make no mistake about it. It is a calling worthy of protection. I intend to act to protect my profession today. I intend to insist that members of the LGBTQI2Q communities are part of the public. And as long as they are not protected, then accrediting TWU cannot be in the public interest. Thank you, Mr. Treasurer.
Mr. Wardle?
Thank you, Treasurer, members of Convocation. I want to start by thanking all of those who have participated in the debate and whose views have informed my decision. And I want to thank in particular my friend Mr. McDowell, who took what may prove to be a somewhat unpopular position and expressed it eloquently. And I also want to thank Mr. Kuhn and Mr. Meehan, whose reply submissions were excellent and I read and reread. I have to say I found this a difficult decision, professionally, personally, morally, and as a practicing Catholic. And I envy my colleagues who found it an easy decision and found it straightforward, because I have not. I don't want to debate the religious convictions sincerely held by the faculty and students of TWU. As tempting as it is to weigh in, that is not our issue. For me, as for others, this decision has to be informed by the Society's governing principles. Our duty to maintain and advance the cause of justice and the rule of law, and our duty to protect the public interest. Having read it and thought about it carefully, I have to say I disagree with the position articulated by Mr. Meehan in the reply submission, that the accreditation decision has to be construed narrowly, based solely on whether TWU graduates will be adequately prepared, educationally and professionally, to practice law in the province. I'm prepared to assume that they will be, but to me that does not answer the question. In my view, our obligations as benchers is to consider broader dimensions of the public interest. Accreditation is outlined in our bylaw 4, and it involves giving recognition and approval to the TWU law program. In other words, our sanction. In my view, we can't turn a blind eye to the discriminatory aspects of the TWU program as embodied in the Charter. We have to consider it and we have to engage with it. I accept that TWU as a religious institution has certain rights, the right of freedom of association and the right to practice their beliefs sincerely held. And I don't think anybody here believes that those rights shouldn't be respected, and I don't think anybody believes that TWU adherents do not sincerely believe their rights. But the community covenant, in my view, goes beyond that. And I, like Ms. Leeper, went back over the last couple of days, and I've been reading more human rights law than I normally read. And I read the Syndicat Northwest case. This isn't simply like a religious believer erecting a religious hut on his balcony and being asked to remove it by the municipality. In other words, there are other fundamental rights at stake. And those rights are the right of gay, lesbian, bisexual, and transgender persons to have access, unfettered access, to an institution that can give them a law degree and ultimately access to this great profession. And as my friend Ms. Bacco said, that's a public good. With all due respect to my friend Mr. Meehan, the analogy to the Bob Jones University case that was made last time is apt. It wasn't the religious beliefs of the students or faculty that was at issue in that case, but a disciplinary code of conduct that prohibited interracial dating and marriage. And what was said by Justice LaRue-DeBay in her dissent in the TWU decision talking about the Bob Jones University case, she said, "In my view, to paraphrase Chief Justice Berger, there can no longer be any doubt that sexual orientation discrimination in education violates deep and widely accepted views of elementary justice." So, with respect to Mr. Meehan, it's not an offensive analogy. It's a worrying and disturbing analogy. This private institution has exemptions, which, as I understand it in my limited understanding of human rights law, allow it to exclude others, at least for certain purposes, or to limit their access for certain purposes. But this is not about TWU's religious or private status as an institution. This is about TWU seeking the right to have us accredit their law school, and we are a public institution. We are the accrediting body, and we have to balance and recognize all the rights involved, not only freedom of religion, but equality rights. And the core of this issue, and it seemed to me at times to be a very complex issue, but the core of it is that the code, as Justice LaRue Debay puts it, or the covenant, embodies discriminatory practices. It's not a proxy for religious belief. And as Mr. Campion said eloquently this morning, the point to consider is when the student is faced with the covenant and has to make the decision to sign or not to sign. Again, referring to Justice LaRue Debay in dissent in TWU, it's an overt but not an illegal act of discrimination. So in looking at the balancing function that we have to carry out, it's not that the rights of LGBT students deserve more protection than the religious freedoms of TWU faculty and students. That would be a clash of rights that we've been told we can't engage in. It's that those rights deserve more protection than the code, which, at least in relation to the teaching of law students, is far removed from the core of religious belief. Now that brings me to what I found personally the hardest question, which is, what about TWU graduates, like this young man who's with us today? Are we discriminating against them on the basis of their religious beliefs by refusing accreditation? In my respectful view, we are not. We don't know what their beliefs are, and we don't ask, and we don't care. We're simply refusing to accredit a degree from a university which discriminates. And I say, as part of the public interest mandate, we should refuse accreditation. I want to add one personal note, as many others have done. Over the Easter weekend in my family, I had a discussion with a group of young Catholic teenagers about this issue. None of them could understand why we're even engaging in it. For them, it's a very straightforward answer. And one of my nephews, who is disabled, said, don't the gays have the right? And the answer is they do have the right. And we've made so much progress in this country where people of my faith can sit down and it's no longer even a matter for sensible debate. So with respect to Mr. Kuhn and his sincerely held beliefs, and to the eloquent and thoughtful submissions of his counsel, I will have to vote no. Thank you very much.
Mr. Brett?
Treasurer, colleagues, and our visitor from Trinity Western. Like some who went before, I have found this issue to be a difficult one on all the same levels that Mr. Wardle just talked about. And my starting point, and I think I started in a different point to highlight where I'm going than Mr. Mercer, and wound up in a different point. My starting point is my own strong personal view that discrimination against individuals based on sexual orientation is wrong and cannot be supported. And as I noted in my remarks to Convocation several weeks ago, I fought for same-sex rights on a pro bono basis, including the M&H case, the Jane Doe case that involved lesbians' access to our healthcare system for assisted insemination. And I personally find it difficult to accept that the Law Society should accredit an institution that discriminates against individuals based on sexual orientation. Over the past few weeks, I've struggled to find a principled means to deny accreditation to TWU. And I'm indebted to many of the benchers who I discussed this issue with, particularly Mr. McDowell, who in my view showed great courage to take the lead in making a difficult and unpopular view to bring it forward. I also want to thank Professor Benjamin Berger, who teaches up at Osgood, and my spouse, Professor Jamie Cameron. We had long conversations about the issue. I recognize that the decision before us cannot be governed by my personal views. It must be governed by the law. What does the law tell us about how we are to balance the right not to be discriminated against on the basis of sexual orientation with TWU's right to freedom of religion? My first point. The law is clear that freedom of religion includes the right for people of the same faith to establish schools and universities and exclude from those schools persons who do not share their religious views. The Supreme Court of Canada made that clear in TWU. And for the record, I'm just going to quote from paragraph 25 of the decision. Supreme Court of Canada said, TWU is not for everybody. It is designed to address the needs of people who share a number of religious convictions. That said, the admissions policy of TWU is not in itself sufficient to establish discrimination as it is understood under our Section 15 jurisprudence. It is important to note that this is a private institution that is exempted in part from the British Columbia human rights legislation and to which the Charter does not apply. To state that voluntary adoption of a code of conduct based on a person's own religious beliefs in a private institution is sufficient to engage Section 15 would be inconsistent with the freedom of conscience and religion which coexist with the right of equality. There's an important point here. TWU is not for everybody. I could not in good conscience attend TWU, nor could my friends of other faiths, the Jewish faith, the Muslim faith, or my friends in the gay and lesbian community. But the Supreme Court makes clear that persons of the same faith are constitutionally entitled to form universities like TWU. Let me turn to my second point. As many have noted, the focus of our discussion has been the community covenant. There's no suggestion that the curriculum of the law school would not otherwise meet our standards. There is no suggestion that the graduates of TWU are any more likely to discriminate than graduates of any other Canadian law school or foreign law schools. This leads me to the conclusion that if we decide not to accredit TWU, then the graduates of TWU would have to come into our process through the National Committee on Accreditation, the NCA process. That process makes no inquiry into whether the applicant is from a faith-based law school, but only looks at whether our curriculum requirements have been met. It would not be constitutional to admit students from foreign faith-based law schools and to deny entry to graduates of a Canadian faith-based school. Nor would it be constitutional to deny entry to our licensing process to individuals because they exercised a constitutional right to attend a faith-based school. I also note that we make no inquiries into whether graduates from accredited law schools share the religious beliefs of those who attend TWU, and nor should we. I say that everyone who's called to the bar in Ontario swears the same oath, which is to uphold the rule of law and the Constitution of Canada. And whether you're a graduate of TWU or any other law school, and you discriminate on the basis of sexual orientation, you're subject to our sanction. So I conclude on this point by noting that while our focus is on the community covenant, it is clear to me that regardless of the covenant, TWU graduates will be permitted to enter our licensing process through the NCA process if our decision is that TWU should not be accredited. This leads me to my third point. Is the principled approach here to deny accreditation to TWU, but to permit entry to our licensing process through the NCA process? And I confess that this is the point that I struggled with the most. Because I say to myself, perhaps we don't need to accredit because the students can come in through the NCA process. And I say to myself, would it be in the public interest for the Law Society to lend its public imprimatur to the discriminatory nature of the covenant by accrediting TWU? And I've heard the people who spoke before me, and I respect their views. I don't like that either. And although this approach was initially attractive to me, I ultimately came to the conclusion that it ran contrary to what the Supreme Court of Canada said in TWU. In essence, that approach would say to persons of faith that there are two doors to our licensing process. One for those who attend a faith-based school in Canada, and another for those who attend secular schools in Canada. In other words, a separate but equal approach. But the Supreme Court of Canada in Trinity Western said that it's not permissible to impose a burden on an individual because of his or her religious beliefs. Here's what the Supreme Court said, and I'm quoting from paragraph 32. There is no denying that the decision of the VCCT places a burden on members of a particular religious group and in effect is preventing them from expressing freely their religious beliefs and associating to put them in practice. If TWU does not abandon its community standards, it renounces certification and full control of a teacher education program permitting access to the public schools. Students are likewise affected because the affirmation of their religious belief and attendance at TWU will not lead to certification as public school teachers unless they attend a public university for at least a year. Let me provide one example of the perilous nature of adopting the separate but equal approach here. Canada has a shameful history of discrimination against those of the Jewish faith, including discrimination against Jews on entry to professional schools. That happened in Canada for many years. And I say, if persons of the Jewish faith had decided to establish a law school that was only open to those of the Jewish faith, would we deny them accreditation and say, we'll not accredit you because you're engaged in religious discrimination, but we'll allow your graduates in through the back door? In my view, the answer to that question is obvious. I conclude as follows. I've read carefully the Supreme Court of Canada decision in TWU, the memorandums of John Laskin and Mammon Jamal, and substantially all of the other vast material that was before us today. Although I wanted to come to the conclusion that we could not accredit TWU, I could not find a principled approach in law to come to any conclusion other than that we are required to accredit the law school. I recognize that many of my colleagues have reached a different conclusion, and that they have followed a line of thought that is principled as well. But it's not one that I could follow. Personally, the conclusion I've come to is not one that I came to easily. And unlike Mr. Mercer, it's not one that I'm particularly comfortable with. However, as a bench of the Law Society, I believe my role is to apply the law regardless of my personal views. From my perspective, it would have been preferable had we sought advice and guidance from the courts, but that wasn't the approach that was adopted. And I say, regardless of the decision that is made here today, it seems inevitable that the issue will be the subject of litigation which will ultimately make its way to the Supreme Court of Canada. And perhaps the Supreme Court will determine that my legal analysis is not correct. And if that's so, this will be one instance that I will not be upset to have the court tell me I'm wrong. Thank you.
I have on the list Susan McGrath, followed by Adriana Toll, followed by Roger Nunn, so get ready. Ms. McGrath. And there are more on the list. I don't want anybody to think that I haven't been putting names on the list.
Treasurer, members of Convocation, representatives of TWU. I stand to express the same view as my colleague Chris Brett, likely not quite as eloquently, but I'll do my best. This is an issue of possible exclusion from the admissions process at TWU Law School. Any student provisionally accepted who refuses to sign and adhere to the covenant will be denied admission. And that's to a program which has very coveted positions. Given the intense competition for law school admission, the requirement that they sign and adhere to a covenant that may offend their sexual orientation or marital status, because it certainly affects people in common law relationships as well, will effectively bar admission to this law school for many. While this is personally abhorrent to most of us in this day and age, particularly given the struggles to obtain equality, it is still incumbent upon us to consider the following 5 points. First, the Federation has approved TWU's law school. They have an approved curriculum which will properly equip the graduates to enter the licensing process in all jurisdictions in Canada. Second, our law society has reserved to itself the right to determine accreditation in this province of a law school approved by the Federation. The factors that we must consider are the standards of learning, professional competence, and professional conduct. And in that regard, we are required to consider the cause of justice and rule of law, and to protect the public interest. The rule of law includes charter rights to freedom of religion and freedom of association. Third, if we vote against accreditation in Ontario, students will apply to the NCA for a certificate, which they will certainly almost immediately receive, given that they have taken all of the approved and required curriculum. In other words, that decision would be more symbolic than effective. Fourth, if we vote against accreditation, we are punishing non-LGBT students and possibly LGBTQ students who may choose to sign the covenant and attend TWU. Fifth, if we accredit TWU, their graduates will enter our licensing program, which includes education in legal ethics, the oath to champion the rule of law and safeguard the rights and freedoms of all persons, and the rule of professional conduct not to discriminate on grounds that include sexual orientation. The fact that a TWU law grad has signed and adhered to the community covenant gives me more confidence that he or she will abide by the oath and the rules of professional conduct. I believe that the TWU law curriculum, like the others approved in Canada, will properly prepare its graduates to practice, to enter the licensing process and practice law in Ontario. In the BCCT case, the College of Teachers did just what many here are proposing we do today. to make our own personal judgments about whether the TWU covenant is discriminatory and therefore against the public interest and the interests of justice. The Supreme Court indicated that we cannot ignore the right to freedom of religion and freedom of association. Despite many of the impassioned arguments to the contrary, we are required to balance the competing rights under the Charter. If, in that balancing exercise, we find that freedom of religion and freedom of association justify the covenant, despite the discrimination against sexual orientation and marital status, I am hard-pressed to reach the conclusion that consideration of the provisions of the Ontario Human Rights Code would trump the Charter analysis. We can send a message that discrimination against sexual orientation and marital status is unacceptable in Ontario, which likely accords with the personal beliefs of many, if not all, of Convocation. But to what end? If that decision is neither legally defensible or practically effective in excluding TWU law grads from practicing in Ontario. Despite the fact that it pains me to agree with Bencher Callahan, I am at this point, inclined to vote in favor of accreditation. Thank you.
We're going to try to break for lunch at about 12:30, so we may not be able to get through two more speakers. But the next up is Ms. Noel.
I wanted to first welcome our guest here from Trinity Western. Thank you very much for your participation. I think I wanted to start with what Mr. Wardle had mentioned when he spoke to the young people, because I have had the opposite reaction from the young people in my family, who range from 22 to 30, and they're both on both sides of the fence with respect to this decision. And for me, it's been very agonizing. I've been listening all morning and last time around with respect to people's views, and I've been very much informed with my colleagues' very thorough review of the case law. I believe, and I want to acknowledge the Treasurer and the Law Society for setting up this process that I believe adheres to the principles of procedural fairness and have been given the ample opportunity for the Trinity Western University to provide their submissions. I'm also grateful for the 3,500 pages on the board books and the ability, and all on our website. I can't think anybody would criticize us with respect to the process. We've been all given the opportunity to review numerous submissions from numerous legal organizations, special interest groups, numerous individuals, law schools, students, equity groups. We've been given the transcript, we've been given the cases. I listened very intently, Mr. Kuhn, to your remarks today and how you brought the life of the community of Trinity Western to this convocation to describe what life is there. I've been attentive and I've been listening to both sides, and I can tell you I also am agonizing over this. My contribution to this debate today is really a summary of the journey that we've come in this decision-making process, and to remind us of the various signposts we must consider when we make and reach our destination. I've listened intently to Mr. McDowell and his brave comments last time, and I've heard Mr. Brett and Ms. McGrath. I want to remind everybody today what TWU has gone through to get here today. That the TWU has gone through a curriculum that has met the academic and professional standards set by the Federation. This program has been preliminarily approved. I've read through the process and where they embarked on the accreditation through the Federation of Law Societies, and one, in my view, cannot but admire their program, which has a curriculum that ensures that law students obtain the necessary courses to earn his or her law degree. In fact, if you read the program and the process of modifying and tweaking some of the courses TWU underwent in order to address the Federation's concerns, you cannot be but impressed with the program. I'm especially intrigued with the practical component where there's an emphasis on law students going out into the community. And the mentoring program and the clinical components of the program highlights TWU's interest and commitment to ready students for the outside world and the practice of law. It is also cognizant of current issues facing the profession as a whole. It plans to devote resources to addressing concerns that our own law society grapples with, such as the shortage of articulated positions and access to justice issues. It's walking the talk in the proposal of the law schools. So as I read through the very engaging process embarked by the Federation, I observed that the process was robust and defensible, and the TWU did meet the criteria. So should students who graduate from this law school with this accreditation blessing from the Federation be able to apply to any province or territory in this country? Are we not discriminating against these students because their law school happens to be an educational institution that requires students and faculty to sign a covenant that mandates an adherence to a conduct that many of us may find abhorrent, that requires sexual intercourse only between a man and a woman who are married, and is discriminatory in its sense? I do not need to repeat what my more eloquent and well-versed and human rights lawyers and people in this room have talked about with respect to the case law, the Law Society mandate, our professional rules of conduct. The fact that the 2001 decision of the Supreme Court of Canada may not be decided the same today, because the lens that they would have to look at today would be through the rule of law in our legislation. 13 years lots has happened. The Criminal Lawyers Association submissions talk about charter cases have developed in the past 13 years. There's talk of there are limits to religious freedom. Their law schools are gatekeepers. We talk about the fact that we at the Law Society continue to have the monitoring group through the Treasurer send admonitions against countries that do not respect the rule of law or are discriminatory. I note that the majority of those who have provided submissions and are opposed to the accreditation TWU believe that there's no real evidence that its graduates would not possess the necessary skills and knowledge to become good lawyers. I'd like us to all consider these factors. I'm, at this point, considering accrediting and voting yes for the TWU. And in doing so, I'd like you to continue to think about the TWU through the lens of our own legislation and social values, but also to be reminded that the BC Human Rights Code, Section 41, allows this educational institution that promotes the interest and the welfare of religion that does not discriminate if it grants a preference to members of the identifiable group or class of persons. BC Law Society has approved accreditation, so have other law schools. If we believe that students graduating there will be abiding by the rule of law and adhere in practice in accordance with human rights legislation and the charter, should we not allow them in when we are governing in the cause of justice in accordance with the law? I'm asking us to continue to consider in a way what we've heard and read and will hear today. I urge us all to continue to be insightful, fair, impartial, and just in arriving at a decision, and consider the legal principles. It is not an easy decision. It is obviously, from what I hear so far, probably in everybody's best interest to listen and make a just decision. Thank you.
I think before we, given the hours, it's nearly 12:30. We'll break for lunch now, and we'll come back continue our deliberations, starting with Mr. Anand after lunch. I do want to say that our colleagues from Trinity Western University have accepted my invitation that they dine in Convocation Hall, so that they will not be with us over the lunch hour, but as we continue our deliberations this afternoon.